fast forwarding it, Sam, you file your first provisional patent.
Yep.
And neither one of us knew about provisional patents, right? We had attorneys that were doing business filings, K1s, but I had to find a patent attorney.
Okay.
So I found a patent attorney, and then it wasn't smooth from that either, because then there was assignment of the patent that wasn't even revealed to us. So I had to find another patent law attorney to watch that patent law attorney, and then I had to get a corporate law attorney to manage the filings to make sure these two were not fighting each other. Because the provisional patent, you can't change later, but it's also not enough where it's got a valuation for a company. It's just, this is your surface level protection to then go out and prove it. So what the USPTO gives you is 18 months to file your non-provisional utility. That is where, when you were talking about your friend, building a $4.5 million, $5 million company, we're leagues past that, because the IP is so much more important than even pre-revenue in medicine, than even something that's generating revenue, because you can't later go back and file more filings if there's already prior arts.
Correct.
So here comes the fun process here. So you then have your patent law attorney, both of them. Then you have your corporate law attorney. Then you need a contract law attorney. And while each of those companies are able to do that, you need somebody that's independent watching in, and then you need somebody that's holding your filings. Because the worst thing a CEO can do, that I've learned, is just file an LLC and then say, oh, I'm going to have X amount of equity, you're going to have X amount of equity.
Correct.
You can't sell the company that way. You actually need to be able to file for a registry that gives you a number of shares outstanding, and you have to choose that. And then that becomes almost like an IPO, where you evaluate what $1 per share is going to be, or 10 cents per share, and then how many shares that you have. So we have the provisional. We have 3 years of data. So we're at year 2 now, technically. And we have the non-provisional. So the non-provisional was 67 pages. And it's very in-depth clinical. You have to hire an engineering firm. I went through 5 engineering firms, and you have to learn how to profile them. So I had to go to night school to learn engineering and CAD systems, all these unique things. And this was I think I ended around the time that I did the Harvard program, but to stay on point here. So you're learning all these things. Then you have to think about how big do you want your team? Who's going to be accessible for the project? Because again, you don't know what financial projections could look like. You don't know what market saturation, market lift, market cap, all these things are about now being able to formalize a financial thesis about the profile of the technology, not just your company. And then you learn, the USPTO comes back and they give you the prior arts. And at the first mark, I think there was 11 prior arts that came back. So some of the things that maybe some CEOs won't share with you is actually what it looked like when your patent is getting reviewed. And I don't mind sharing that. I think transparency will help other founders, or even people that are not founders but are in vice president positions. I think this would help them understand that. So you can't ignore it, number one. So if they come back with an opinion and they deny the claim, you can't just ignore it and say, that's okay, we'll still build the tech. You have to modify everything within the boundaries of where they're going to allow you. So you start out at 50 claims, somewhere around 35, 50 claims, and the USPTO starts to say, nope, 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 and you get into a really tight window. And if you modify the technology outside that window, they'll cancel it. If you modify the technology outside that window, but it still has validation, they're going to ask you to amend the claims further. And you can't go backwards, because now anything that you file becomes a prior art.